All right, folks, we have another judge rejects the Department of Justice's argument that cannabis consumers have no Second Amendment right. We're going to dive into some of these details. Again, if you support my work, hit the subscribe button, smash that bell notification. Let me know your thoughts in the comment section as we unpack this topic. So we have U.S. District Judge Kathleen Cardone was unimpressed by the Biden administration's argument that marijuana users are too dangerous to own guns. By the way, those folks over at YouTube, we are talking about laws and a judge's order. I am not talking about my condoning of the devil's lettuce and guns, all right? So don't get too uptight on me here, YouTube. Here we go. We're going to dive into these details. A federal judge in Texas recently agreed with a federal judge in Oklahoma that the national ban on gun possession by cannabis consumers violates the Second Amendment. Kathleen Cardone, a judge on the U.S. District Court for the Western District of Texas, also concluded that the federal ban on transferring firearms to an unlawful user of a controlled substance, first imposed by the Gun Control Act of 1968, is unconstitutional. By the way, I'd like to know your thoughts, guys. Those that subscribe to this channel, do you think folks who use the devil's lettuce, whether it be for recreational or medical purposes, should still have their Second Amendment rights? If so, put a 1 in the comment section. If you think that folks are in possession of or users of the devil's lettuce should not have their Second Amendment rights, put a 2 in the comment section. Really curious what you guys think. So, moving on. The case involves Paola Conley, who was charged with illegal possession of firearms under 18 U.S.C. 922 G3 after El Paso police found marijuana and the guns in her home while responding to a domestic disturbance in December of 2021. Conley, who said she used marijuana to sleep at night and to help with her anxiety, also is charged with violating 18 U.S.C. 922 D3 by transferring guns to her husband, a cocaine user. Both gun offenses are punishable by up to 15 years in prison. As a preliminary matter, Cardone held that Conley's Second Amendment claims were not precluded by prior decisions in which the U.S. Court of Appeals for the Fifth Circuit, which includes Texas, upheld Section 922 G3. Those decisions, she noted, preceded the Supreme Court's June 22 ruling, New York State Rifle and Pistol Association versus Bruen, I'm sure many of you are aware, which said gun control laws must, quote, be consistent with the nation's historical tradition of firearm regulation. Last February in the United States versus Rahami, the Fifth Circuit concluded that Bruen required it to reconsider decisions upholding the federal ban on gun possession by people subject to domestic violence and restraining orders. By the same logic, Cardone says in an order published last week, the Fifth Circuit proceedings regarding Section 922 G3 are no longer binding. As it has in previous cases involved in the same law, the Biden administration argued that the gun ban for marijuana users meets the Bruen test because it is relevantly similar to colonial and state laws forbidding people to publicly use or carry guns while intoxicated. Like U.S. District Judge Patrick Wyrick, who deemed that ban unconstitutional in the Oklahoma case last February, Cardone was unpersuaded by the Biden administration's analogy. The historical intoxication laws cited by the government generally address specific societal problems with narrow restrictions on gun use, while 922 G3 addresses widespread criminal usage and issues with a broad restriction on gun possession, Cardone notes. The laws, therefore, are not relevantly similar in how and why they regulate firearms and do not suffice to establish the constitutionality of 922 G3. In 1655, I think it's pretty cool when we go and study laws in the past, going all the way back to the year 1655, a Virginia law, for example, prohibited shooting any guns at drinking establishments establishments, at marriages or funerals, for example, to show why that law is not relatively similar to the ban that Conley challenged. Cardone draws an analogy with contemporary laws that prohibit driving under the influence, or a DUI. The Virginia law regulated guns in much the same way, Cardone writes. It prevented individuals from using dangerous equipment while intoxication might impair their abilities and judgment. Consider instead a law that would prevent individuals from possessing cars at all if they regularly drink alcohol on the weekends. Would it make sense? Would it? Nobody would say that this hypothetical law is similar to a DUI law in how it regulates the vehicle. The hypothetical laws focus on possession rather than use of the vehicle, imposes a much greater burden on drivers. A similar distinction exists between 922G3 and the Virginia law. State laws enacted in the 19th century likewise were aimed at people who were publicly carried firearms when they were drunk. By contrast, Section 922G3 covers all cannabis consumers, including those who live in states that have legalized marijuana, even when they say they are not intoxicated, and it applies to private as well as public possession. A true rule regarding alcohol would categorically ban gun ownership for every single drinker in America. By the way, this is all coming from Reason. All right. The government also argued that Section 922G3 is consistent with a purported tradition of disarming unvirtuous people. It is unclear whether legal authorities at the founding era would consider Conley's homebounding drug use unvirtuous, Cardone says. She notes colonial era jurist William Blackstone's distinction between public and private vices. While the former are subject to the punishment of human tribunals, he said, the latter are subject to eternal justice. Blackstone explicitly applied that the distinction to drunkenness. Conley alleged drug use more resembles private drinking than public drunkenness, casting doubt on the idea that history supports criminalizing or disarming her for this behavior, Cardone writes. And more generically, nothing in 922G3 limits its applicability to public dangers or active intoxication, putting it out of step with colonial era attitudes. Cardone was equally unimpressed by the government's argument that Conley was disqualified from owning guns because she was not law-abiding. While her marijuana use, if proven, would violate federal law, Cardone says that the offense is a nonviolent misdemeanor, and no one even today reads Second Amendment history to support the disarmament of literally all criminals, even nonviolent misdemeanors. Notably, Cardone is quoting a 2019 dissent that the Supreme Court Justice Amy Coney Barrett wrote as a judge on the U.S. Court of Appeals for the Seventh Circuit. Barrett argued that the federal ban on gun possession by people with non-violent felony records sweeps are too broadly. In making that case, she took it for granted that the nonviolent misdemeanor is not enough to justify depriving someone of his or her Second Amendment rights. As applied to Conley, such a rule seems especially perverse, given President Joe Biden's position that marijuana use should not be treated as a crime at all. Cardone notes Biden's blanket presidential pardon for people convicted of simple marijuana possession under federal law, because that pardon applies to conduct that occurred before October 6th of 2022. It would cover the marijuana that police found in Conley's home. See, for non-gun owners, of course, we know it's okay, but for gun owners, it's always the agenda. What about the government's claim that marijuana users like Conley are too dangerous to be trusted with guns? Even if history broadly supports disarming dangerous individuals, there's very little evidence that Conley herself is dangerous, Cardone says. The government has not alleged that she committed any violent or threatening acts. Instead, its core allegation that she possessed and simply used marijuana. Cardone notes that more than 20 states have legalized recreational use of marijuana, and millions of U.S. Citizens regularly use the substance. She thinks it strains credibility to believe that taking part in such a widespread practice can render an individual so dangerous or untrustworthy that they must be stripped of their Second Amendment right. Cardone also notes that Section 922G3, unlike restrictions that hinge on a conviction or a judicial order, deprives people of their Second Amendment rights without a hearing or any preliminary showing from the government. They must choose to either stop their marijuana use, forego possession of firearms, or continue both practices and face up to 15 years in federal prison. Cardone extended her analysis to the charge that Conley illegally transferred guns to her husband. His behavior, unlike Conley's, did indicate that he posed a danger to others. Police arrested him after they heard several shots and observed him standing at his neighbor's door with shotgun. But in fact, Cardone says, does not preclude Conley's facial challenge to Section 922D3, which applies even to non-violent drug users. Because banning gun transfers to drug users is banning possession. Cardone concluded the provisions raised the same concerns in Section 922G3. She therefore dismissed both charges against Conley. Unlike Cardone and Wyrick, Alan Windsor, a judge in the U.S. District Court for the Northern District of Florida, thought the government's historical analogs were close enough. Last November, Windsor dismissed a lawsuit in which Florida medical marijuana user patients sought to recover their Second Amendment rights. The plaintiffs are asking the U.S. Court of Appeals for the 11th District to overrule Windsor's decision. In response, the Biden administration continues to argue that forbidding cannabis consumers to own guns is like telling people not to carry guns when they are drunk. The Justice Department, meanwhile, is appealing Wyrick's decision, and it can be expected to appeal Cardone's as well. For those keeping a partisan score, it is notable that 3 of these judges were appointed by Republican presidents: Cardone by George W. Bush, Wyrick and Windsor by Donald Trump. Their disagreements seem to reflect the evolving conservative views of marijuana as well as the impact of Bruen. Whatever you may think of that, cases challenging the constitutionality of 922G3 will soon be considered by 3 federal appeals courts: the 5th Circuit, the 10th Circuit, and the 11th Circuit. Assuming they reach different conclusions, the Supreme Court is going to interview and decisively settle the question of whether the right to keep and bear arms includes an exception for those people who dare to consume the devil's lettuce and its substance that legislators deem intolerable for more than 2 centuries after the Second Amendment was ratified. I think that's a great article, again, coming out of Reason. Again, folks, I'd like to know your thoughts on this subject. If you've taken my concealed carry classes, you know that we have discussed it in the class, but I'd certainly like to know what you all think. Again, folks, please support my sponsors, and in this case, it is the USCCA providing you education, training, and self-defense liability insurance. If you click on the link in the comment section or in the description, you'll see a free, 100% free 2023 gun laws guide. It is updated in real time. Great information, keeping you educated and legal and a responsible protector at that. Again, click on the link in the section and get your free guide. Just plug in your email address once you click on the link, and you can get it. It's yours to keep as a gift from myself and the USCCA. Again, guys, support the sponsors of my shows. Let me know your thoughts. I appreciate all the support, folks. And as always, remain safe.